Namaskar. As you know, as of July 1, 2024, 3 new criminal laws have come into force. Instead of the old Indian Penal Code, we have the Bharatiya Nyaya Sanhita, called BNS. Instead of the Criminal Procedure Code of 1973, we have Bharatiya Nagarik Suraksha Sanhita. And instead of the Evidence Act, we have the Bharatiya Sakshya Sanhita. Now, these laws will be scrutinized in time to come by courts, but there's a lot of controversy about the nature of these laws, the manner in which they have been drafted. And what's important is that the Home Minister, when introducing these laws in 2023, and they are now in force from 1st of July 2024, made a statement that he wants to get rid of the yoke of the colonial era, that these laws were all laws of the colonial era, and that now we have drafted more modern laws, getting rid of the colonial era. 90 to 95% of the provisions of the IPC or the Evidence Act or the Code of Criminal Procedure have been retained. Only 5 to 7% have been changed, and those changes also are the subject matter of a lot of controversy. Now, just before we introduce the panelists who are here to discuss, and we have really very eminent people, I just want to mention one fact. There is a provision in our Constitution, which is Article 21, which says that no person shall be deprived of his life or liberty save in accordance with procedure established by law. So the 3 criminal laws fall within this fold. Why? Because the Penal Code, as it was, took away your liberty and your life if you committed an offense under the Penal Code. The procedure on the basis of which you were to be tried were the Criminal Procedure Code, which is also prescribed by law under 21, and the manner in which the facts have to be proved for you to be convicted is the Evidence Act. So the 3 laws are part of Article 21. So we're going to examine whether these laws are at all consistent with Article 21 of the Constitution or not. But before we do that, let me introduce the panelists that we have. Mr. Chidambaram, as you all know, famous lawyer, most eminent lawyer for years, has been, I think, 6-7 times Member of Parliament from Sivaganga. Now he's given it up, and Karti now is a Member of Parliament there. He presented the Dream Budget of 1997. Before that, he's been Minister of Commerce. Before that, in Rajiv Gandhi's time, Deputy Minister of Commerce, Minister in the Department of Personnel, presented 9 budgets, has been the Finance Minister, the Home Minister. So, you know, he is the best person to really talk about the government side as to how laws are framed and how these laws are inconsistent. We have Justice Madan Lokur, who, of course, as you all know, has been Chief Justice of Andhra, Chief Justice of Guwahati. He was a senior advocate, then became an ASG for a while, and then he's been a judge in the Supreme Court for several years, several landmark judgments, especially in the context of the environment. We have Mukta Gupta, who, of course, I didn't know that you did your BA in zoology, right?
I'm a science student.
You're a science student. I never knew that, but I discovered that. And she's been a judge of the Delhi High Court from 2009 to 2022, and she has rendered some remarkable judgments. She was standing counsel on the criminal side of the National Territory of Delhi. She was with the CBI for several years. She's done the trial as a prosecutor in the Parliament attack cases and many other such important cases, the Fish Katara case and many such other cases. So, and she is now lecturing on these laws all over the country, also in the IAS Academy. So we have 3 really most eminent participants in this Dil Se dialogue. So let me start with you, Chidambaram ji. Is this a getting rid of the British era?
I've said it is a posthumous tribute to Lord Macaulay. Because 90% to 95% of the Indian Penal Code has been retained. There are 511 sections, 23 plus 2 chapters. 18 chapters have been cut and pasted. Not a word has been changed, not a comma has been changed. So in fact, you have conceded, admitted your inability to improve upon the language of Lord Macaulay. So what colonial law have you overhauled? I am objecting to the manner in which these new laws were drafted. If you are revising the Indian Penal Code, which is of the year 1860, and the Indian Evidence Act, which is of the year 1872, and the CRPC, which is 1973, you should have sent it to the Law Commission. What is the Law Commission for? The Law Commission is only for the purpose of advising the government how to revise laws. If you are contemplating a complete overhaul of the law, you should have sent it to the Law Commission. The Law Commission was bypassed. You handpicked a few professors of universities who held full-time jobs, and they were able to devote part-time to this drafting exercise, and they have done their best, which is not good enough. That is why you have this complete copy and paste laws. I object to the procedure, and it's certainly not a complete overhaul of the criminal laws.
Madanji, what is your view on this?
Yes, I agree with him that, there are a few things, like he has said, about the colonial aspect. Now, there are some expressions that have been used in the Indian Penal Code. A woman quick with child, all right? Now, that's an expression, I don't think anybody has heard of that for the last 100 years.
That's true.
Right? Then, but it's there in the BNS. Then you have an instrument for, some kind of a surgery called a trepan. I don't think anybody has heard of that instrument. And that is used in the illustration in the IPC and also in the BNS in case a person falls off his horse and injures his skull, and the surgeon uses a trepan on him.
Okay.
Now, how many people do you know of who fall off a horse, injure their skull, and there's a surgeon hanging around with a trepan? So, I mean, it's just an exercise undertaken for the heck of it. That is one. The other thing is that, I'm a little upset at the use of the word Bharatiya. Indian Penal Code, Indian Contract Act, Indian Succession Act, they were all drafted by the British Parliament, applicable for India. Now, why do you need to use the word Bharatiya or Indian for a new law? I mean, Indian Parliament is doing it.
Yes.
Just call it the Nyaya Samhita.
India won the Cricket World Cup this time in T20.
Yeah. Also, why do you want to use the word Bharatiya? I mean, I don't have anything against the word Bharatiya for Indian, but it's not necessary for a law drafted by the Parliament of India for Indians.
Okay.
Okay. Are you going to call all our, say, the Biodiversity Act, which has been enacted, are you going to call it the Bharatiya Diversity Act, Biodiversity Act? Are you going to call the Finance Act the Bharatiya Finance Act? Why are you doing this,
But let me take this forward. It's very interesting. You mentioned this, but it's Bharatiya Nyaya Samhita.
Yeah.
Now, what I don't understand in this title is under the penal code or the Nyaya Samhita, who prosecutes you? The state.
Yes.
The individual doesn't prosecute you, right? What's the purpose of this prosecution? That somebody has committed an offense not against queer person but against society. All these offenses are offenses against society. So the purpose of the law is not justice. The purpose of the law is to punish him.
Yes.
So how do you use the word nyaya?
Yeah.
Nyaya is when one person is making out a case against another person and the court decides as to who is right. Then it's justice. Here you are punishing. The intent of the law is to punish the individual. So therefore this Bhartiya and Nyaya, according to me, are words which are inconsistent with the intent of Article 21.
Absolutely. See, my take on the BNS is, its preamble says it's a act to consolidate the penal provisions. They have introduced some penal provision from special statutes, like we have Macoca, GCOCA, AP COCA, where organized crime is punished.
Exactly.
They have been brought in BNS as sections 111 and 112. The definition is verbatim the same. Now the effect of this is, the police is at liberty to use either the BNS provisions or the special enactment. Similarly, section 113 BNS has an offence of terrorist act. The definition is again the same as UAPA.
Correct.
Now again, it is the discretion of the police to either go take the BNS route or the UAPA.
And the procedures are different.
Procedures are different. Now, if there are certain presumptions available to the prosecution over there are certain checks which are there in those special statutes. And at the same time, when they wanted to amend and consolidate the acts, they have brought these provisions in BNS. At the same time, they have not repealed those special statutes. Either they would have consolidated all the penal provisions into one statute. It would have made much simpler than going to different statutes, so that interpretation of one provision would have been applicable to all.
Electoral offences,
Yes.
RP Act,
Yes.
RP,
have been brought into
Has
the,
been brought in, yes.
the new law.
new law.
But coming to the issue of the, hangover of the colonial era, the two provisions, and I want your comments on that, which really are a hangover of the colonial era, is one, to arrest a person on suspicion and to keep him in police custody for 15 days. Right? There is no penal code in the world which allows you to keep the police to allow to keep you in custody for 15 days. No such parallel provision in the world. So that's the hangover of the colonial era. What's the reason for police custody? You have the right to investigate, you investigate. You find material, you punish me, you prosecute me. Why do you need police custody? This was needed when the British were ruling us. This is the hangover of the colonial era. 2, sedition. That's the hangover of the colonial era.
It's still there.
It's in a much wider
In
form.
a much wider form, yeah.
Wider
You're
form.
right. Yeah.
A moment you threaten the security of the state, integrity of the state, then you can be put to life, put away. Now, these are the two real provisions which are part of the colonial era, and they've retained them. Then what are they? What is this basis on which you say that you're getting rid of the colonial era? In fact, you're perpetuating the provisions of the colonial era. You would know better. In which country of the world do you have police custody?
All over the world, the arrest by the police is reasonable grounds to suspect. And that is not the subjective satisfaction of the police officer. So he has to have some grounds. Now here the word uses reasonable suspicion. What was used in section 41 of the CRPC has been retained over here.
Correct.
If when the word uses reasonable ground, it shows that there should be some material with the police officer to affect the arrest. So there is that dichotomy continues in these provisions, plus there is no congruence, I would say, like they have brought the provisions of registration of FIR irrespective of the area of where offence is committed. We had section 154 CRPC and now it's section 173 BNSS. Now the only addition in 154 1 CRPC is irrespective of the area where offence is committed. So if an offence is committed in one state, FIR can be registered in another state, investigation carried out, and all incidental procedures including arrest carried out, which is further fortified by section 185 BNSS, which says that the confession will be recorded by the magistrate where the
Arrest.
FIR is registered.
That's correct.
No, but who will investigate? That police?
That police.
That police.
That police.
It has no
will-
jurisdiction at all.
Therefore, Gujarat police can come to Delhi and arrest anybody.
But-
and then investigate. You can get a confession, but the charge sheet will have to be filed where the offence is committed.
Correspondingly, the provisions where the trial has to take place are verbatim the same as CRPC.
Where the
which
offence-
there were 177 to 184 CRPC are verbatim in 197 to
How can the
204
police of one state investigate a crime committed in another state?
But that's what is
That's
No, no.
what-
provided.
Even
Irrespective of the-
CBI can't investigate
Yeah,
without
without
the
You say
consent.
irrespective of where the offence is committed,
committed.
another you can investigate.
It
That's
doesn't
what the-
qualify that within that state.
No, that's why part of the cause of action, part of the crime must have been committed within that state. You can
No,
register.
the word uses irrespective of the area where offence is committed.
obviously
That's an
unconstitutional.
addition.
Contrary to
in
all
173
principles of
1
law.
BNSS.
No, contrary to federalism.
Yes,
Yeah.
So this is what they will do. They'll arrest anybody at any place. Now these are this is much worse than the colonial era
No,
law.
I think that they have given a greater latitude to the police
Yes.
and have restricted the discretion of magistrates. See this, as I understand, 15 days police custody, irrespective of the
Yes.
point you made out, is 15 days in the first 15 days.
Yes. That's the
That is
present
the
position.
way
That's-
the
it
present
was.
law is being applied.
Correct.
Today, the 15 days can be in parts and spread over 40 to 60 days
Correct.
in a 60-day to 90 days of total custody.
Correct.
Which means, effectively, for 40 to 60 days, nobody will get bail in this country.
Absolutely.
Because I, the police, arrest you and ask for your custody for 3 days, then I tell the magistrate I'll come back in a week and
After
ask
1
you
week
for
or
3
10 to
days.
20,
Now,
correct.
what will the poor magistrate do? He will grant police custody for 3 days, send you home, and then take police custody. He will send you to judicial custody.
Judicial
So
custody.
40 to 60 days, nobody can
And
get
if you
bail.
ask for bail, he'll say, but the investigation is yet to be
Yes.
completed because they've got another, 12 days to investigate and keep you in police custody.
Nobody will get bail.
Nobody
There is
will
a
get-
proviso to section 480 BNSS which provides that the accused being required for police custody beyond the first 15 days will not be the sole ground for refusing grant of bail to the accused. But we all know if one of this claim is taken that the accused is still required for custodial investigation, then the grant of bail becomes much difficult.
You also look at it from another point of view of the accused person. All right, he's in police custody for 3 days, assuming the judge gives him bail after that. All right, he's on bail for 7 days. Again, the police come and say, listen, we want custody. So he'll be going home for 3 days or 1 week, coming back into police custody, and like a shuttlecock, he'll be going between home and
Effectively,
So
no
that is
magistrate
if-
will grant
Yeah,
bail.
If he is,
no,
if
but
he is
even if
not
he
on
does,
bail.
Even if he
That's if
If
he's not on bail. Not on
if he is
bail.
not on bail.
Huh.
That
It
police
can't be that
custody
he is
will
sent
be-
home.
yeah, once he is released on bail, then they
Then
can't take the police custody.
Right, naturally, but that's the law.
That they cannot.
Okay.
Then they cannot take.
Okay.
Yeah, but what will happen is,
So
as-
then
That is why he will
then
not
they'll be-
grant him bail.
That's
Yeah,
why,
that's why what
despite
he
this
said.
provision to 480 BNSS,
Yeah.
this will be a ground always to deny bail to
I
the
need
accused.
them- I need him for custody.
The magistrate will say, but they have yet to, they can take him to police custody anytime. They will say, we need to confront him with this witness, need to confront him, as they do now.
Yeah.
Right? And nobody will get bail for 40 days in a 60-day charge sheet case and 60 days in a 90-day charge sheet case. So what are you going to do? I mean, this is, and then you say that this is we want to get rid of the colonial era. I mean, I just don't understand.
See, the Supreme Court has said in a couple of judgments, when you arrest a person, the magistrate must examine the legality of the arrest. And then Chief Justice Chandrachud said, the power to arrest does not mean the necessity to arrest.
Correct.
So the magistrate must ask about the legality of the arrest and the necessity for the arrest.
But the problem,
But this law does not even reflect that development of the law.
but this has been happening in the past also, if I may say so.
No,
Even
in the
under
past,
the old code.
that is why the judge-made law said legality of arrest and necessity of arrest.
Correct, but even under 41A, you can, where the sentence is 7 years, you can call him, and at that point in time, you can arrest him. You don't have to give reasons.
But if they were modernizing the criminal jurisprudence, they should have added legality and necessity.
They should have, in fact, added Arnesh Kumar's judgment and all into
Correct.
it.
But apart from that, supposing, how are you going to decide on the legality of the arrest unless the accused knows what is against him at that point in time? If you really want a reasonable law, which is fair, then if you say these are the reasons why we want to arrest him, that reason should be given to the accused so that he can ask for bail. Otherwise, it's between the trial judge or the special court and the prosecutor. Now, how does the accused know on what grounds he's being arrested and how his arrest is legal or not legal? If you want to modernize the law, this is where you
none of the landmark Supreme Court judgments of the last 10 years are reflected in the new law.
They are not.
So we'll have to go back to the court and say, notwithstanding the new law, the principles will have to be applied.
90 to 95% it is verbatim this.
Correct.
There is tweaking done in most of the provisions which there are changes, but they have not maintained a continuity in the sense, like if one provision is there, then that should be put in continuously towards the end. But there are amendments, later on there are no amendments. So there is so much of dichotomy when you read the provisions, because others have been directly retained as it is. As I said, the trial, think of a charge sheet, investigation by another state police, and the charge sheet back to the same place where the offence has been committed. Now, who will grant bail? What will happen to the remands already granted? When will the papers be transmitted? And during the transmission of papers to the court of competent jurisdiction, what will be the stage of that period of remand called? Because cognizance will be by the magistrate who is competent to do the trial. Now, one day they cannot just transfer it to the competent court. Supposing they do it on the 90th day and matters are then transferred to the competent court, the charge sheet. What will be this inter agonum custody called? Will it be an illegal custody?
These are all very serious issues.
These are issues which
If
will
I
need
may
consideration.
read the provision, the new provision in the BNS on sedition, this is what it says. It doesn't call it sedition, but this is what it is. It says, it penalizes the following: exciting or attempting to excite secession, armed rebellion, or subversive activities, right? Encouraging feelings of separatist activities or endangering the sovereignty or unity and integrity of India. Unity and integrity. These offences involve exchange of words or signs, electronic communication, or use of financial means. So now you know you have a protest march, you have a bandh, you have some form of violence, it will be subversive, it will affect the unity of India. There are some speeches made which are incendiary, and you will be put in for life. For life. This is the definition of sedition.
This is wider than 124A.
Wider than 124A. So this is, now let me give you another definition of terrorism. This is even more serious. Includes an act that intends to threaten the unity and integrity and security or economic security of the country. It becomes terrorism.
This economic security
Of the
phrase
country.
had already been added.
And membership of an organization
Yes,
makes the person a terrorist.
yes, that of course, but that's under the...
That was there, that's there in
earlier
UAP also.
UAP also. Strike terror in the people or any section of the people. So any section of the people, you strike terror. And what do you mean by striking terror? You can do it by any means.
Yeah. You see, one of the problems that I find, not only with these laws, but generally, is on the question of application or the implementation of the law. The police will implement the law in the way they think. You know, whether it's right or wrong, it doesn't matter. So a tweet, for example,
Yes,
can amount to sedition.
right.
And they have arrested people for tweets.
Yes, that's
Okay?
true.
Right. So now, even today, under the new BNS, if somebody gives a tweet which the police think is, subversive and this, that, and the other, they'll put that person in.
That's right.
So implementation also is, I think, a very, very crucial aspect.
But laws of this nature have to be defined
Yeah,
very carefully.
you have to be very precise.
Exactly. This is the problem. There's so much vagueness in the definitions that the police officer will do what he wants.
Yeah.
Kapil, I think economic security was eventually dropped. What are you reading? Which section?
I have this. I'm checking the section on terrorism.
Terrorism, 152,
Yes.
which is equivalent to 124A.
Yes. No,
You're reading
124A is sedition.
Yeah, sedition.
I'm talking about terrorism.
Terrorism, yes.
That's 113.
That is there.
Yes, that's correct.
That's the serious part, which means that a
Financial.
big financial scam is terrorism.
Yeah.
No, 152 also uses whoever by use of financial means excites secession, etc., sovereignty, unity. So financial means if you endanger unity and integrity of India, you can be punished.
You are a
for
terrorist.
sedition.
You then become a terrorist.
No,
You can be punished also in this.
it will come under 152 also.
That's right.
This is punishment with imprisonment for
With what
life.
mindset have these people drafted these laws? I don't understand.
See, none of them was a practicing lawyer except Mahesh Jetmalani. All the rest are professors. I've seen the names. They were all,
I must share this with you. You, of course, gave a dissent note
yes.
to the recommendations,
In
if
the
I remember
standing
correctly.
committee.
In the standing committee. But I know for a fact that I gave the names of several prominent lawyers in the Supreme Court to come as witnesses before the committee, and names were not.
No, we gave a list of witnesses, of judges.
They were not called.
Justice Lokur was one of them, we said.
But they were not called.
No one was called. The chairman summarily rejected our list. We wanted judges, lawyers, jurists to be called. None was called.
I mean, this is shocking. Now, take the definition of organized crime. It's even more interesting. Organized crime includes offenses such as kidnapping, extortion, controlled killing, land grabbing, financial scams becomes organized crime. And cyber crime carried out on behalf of a cyber syndicate. Attempting or committing organized crime will be punishable with death or life imprisonment. I mean,
The dichotomy in this is 406 criminal breach of trust is not an offense under PMLA. So it's not thought to be serious. Whereas under this economic offense is an organized crime. Whereas 420 IPC, cheating, which was an offense under the PMLA, scheduled offense, is a petty organized crime under 112.
Oh.
And
cheating is a petty organized crime.
Cheating is a petty organized crime.
It was very petty of them to say that.
See, 112 includes cheating, theft, snatching, unauthorized selling of tickets. Cheating is under petty organized crime.
What is
and
the
it's an
punishment?
offense. The punishment for this is imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years and also shall be liable to fine. Now, under section 46, a subsection has been included which provides for handcuffing.
Yeah.
Supreme
Yes,
Court
that
in
was-
Prem Shankar Shukla
said yes, yeah.
clearly said that the nature and gravity of offense cannot be the criteria. The same is violative of Article 21 of the Constitution. Now, the nature and gravity of the offense is the criteria and offenses.
That will be decided by the police officer.
Yes.
There are several retrograde provisions. For example, adultery
Yes,
Has
that's
been
the other
brought
big
back.
issue.
Yeah,
Brought back,
yeah.
yes.
brought back. Solitary confinement has been introduced as a punishment. And then they have now said all witnesses can be deposed by electronic
That's
means,
correct.
Video
including the police officer.
Yeah. How can that be?
I mean, he has to be cross-examined. You
Exactly,
have to have eye contact with him. And then all documents can be proved by the successor. Not only when the officer is dead, even when he's transferred,
Yes.
the successor can
Can
prove
prove
the
that. How
document.
can that be?
Now, if a man prepares a document, the registrar of documents registers a document, he must come and give evidence. But he can,
And that
his
too-
successor, what will he say? He'll say, this
Yes,
is my
this is what I
right,
got.
this is the
Yes,
record I've got.
And that too, if you oppose the document,
If you want to oppose the document, yeah.
dispute the document.
No, these are retrograde provisions, and the sooner they are challenged, I think the better it is.
Okay, let me give you another definition of mob lynching.
Of mob lynching.
Mob lynching. It
Yeah.
says, murder or grievous hurt by 5 or more people on specified grounds as an offence. These grounds include race, caste, sex, language, or personal belief. Punishment for such murder is life imprisonment or death. So you put somebody, 5 more people, 34, you use 34,
149.
149 here, and call it mob lynching. Now, they will not do anything about the previous 153A. On that, they have not done anything.
Yeah.
That's the law that needs to be reformed. Because here, very, very important dignitaries are actually misusing those provisions, and nobody takes action against them. That's the law that should have been changed to make it more modern. But they've not done any of that. And this use, and that's the other thing that I want to point out, this electronic, this is fine. I think that's a good step. You have to use electronic means nowadays we're going into the electronic age. But where's the infrastructure? Where's the electric?
They've given 5 years period for
Yeah, but in the meantime,
establishing
what
the
happens?
forensic
In the
labs.
meantime, what will
In the
happen?
meantime, thus you will take the help of the adjoining states.
Yeah.
What adjoining state?
But also, what Mr. Chidambaram says, if you want to cross-examine a witness, he should be there in front of you.
Absolutely,
You
absolutely.
you have things like demeanor and all that, body language.
No, you don't know what he's accessing to.
Yeah.
If it's electronic, like even guidelines were laid in Praful
Gandhi.
Pradvai's case by the Supreme Court, saying that he has to be present as a place, there should be somebody to monitor the evidence, and he will be at the High Commission, there will be a competent officer, then only deposition can be there. Now electronically you never know that the witness has opened his statement in his front and he's reading out from him.
What about approver's evidence?
Yes.
Unless you
You
eye
cross-examine,
contact
of
with him,
course,
nah,
yes, of
you have
course.
to look him in the eye.
That's
He
right.
must look you in the eye. And if he casts his eyes down and he fidgets, all that has to be noticed by the judge. That this guy is obviously lying, he is not willing to look the defense counsel in the eye or the accused in the eye.
You at one stage raised this point about community service.
Yes.
This is another
I
issue.
said you have to define it first.
Yeah.
Now-
Without defining, for example, the guy in Pune or somebody, he was asked to write a 300-page, 300-word
word
essay.
essay.
Is that community service?
So they have given in the explanation to BNSS that it is a court-directed work without any remuneration. So that's the definition given. It's provided as a punishment under the BNS, but the explanation is given under BNSS that it's a court-directed work without any remuneration. That's it. So very wide
What
power
is
given.
community service? For example, somebody can be told, you do kar seva in a gurdwara. Somebody can be told, you go to a temple and sing bhajans for 2 hours. Is that community service?
Oh, it all depends on what the judge wants.
The judge wants.
So you have to define. Nah?
Now, but see, it's what's interesting. In which cases is there community service that's required under the law? It says this punishment to offences such as theft of property of less than 5,000, attempt to commit suicide. Attempt to commit suicide, you will have to go do community service.
Go for community.
Yes, intent to restrain a public servant. attempt to restrain a public servant. So if you tell a policeman, don't do this, you'll have to do community service.
No,
Just
and
imagine.
every protest, civil
Yes,
protest,
yes,
civil
exactly.
disobedience,
Yes,
you resist
you'll
a public servant.
all those people will have to do community service. Then more important, appearing in a public place intoxicated and causing annoyance. So young people, if they if they drink too much and they are intoxicated and causing annoyance, they will have to be, what is this going on? I mean, nobody has applied his mind.
Then there is no corresponding provision which says whether the community service will be treated as a punishment, will have the stigma of a punishment like earlier in the probation. If probation is granted, it was very clear that it will not have the stigma of a punishment. So community service, whether it will carry the stigma of a conviction and a punishment, is also not
it is a punishment.
It's a punishment.
Yeah,
So, but whether it will carry that stigma or not is not there.
Yeah. The Probation of Offenders Act
was very clear on this aspect.
but this is not clear.
Once you leave him on probation, then it would not carry any
Yeah, correct,
stigma
correct,
of a conviction. But this is not clear when you leave on community service,
It
whether
will-
the stigma will be there
It
or
will
not.
carry a stigma because it's a punishment.
I want to
Which is
raise another
undefined.
point, subject to correction by the former judges. The rank of assistant sessions judge has been abolished. There's no assistant session judge now, which means I'm told by criminal lawyers that all offences punishable with imprisonment exceeding 3 years, limit of a magistrate, and exceeding 7 years, limit of a chief judicial magistrate, must be now tried by a sessions judge. If that is correct,
No, sir.
all
No
first
trials will take
appeals will
place.
go to the High Court.
Yes.
No, the trial can be by the bar was earlier on the chief judicial magistrate giving punishment more than 7 years, even if the trial could take place. The trial was as per the schedule to the CRPC, which schedule is retained. So, even if it is triable by the chief judicial magistrate, there is a limit of this punishment which can be.
He can
prescribed.
try the matter.
He can try.
This is the kind of
No,
provision.
we have all now, see, virtually at least in Delhi and many states, there were hardly any assistant session judges. We had additional session judges who were equivalent to session judges.
But that's additional session judge.
So additional session judges will be
That
there.
is there, that is there.
Session judge would include additional session judge. They have abolished magistrate of the third class. So it will be magistrate first class, which will
Second
include the chief judicial magistrate and the magistrate second class. So there will be only 4 category of judicial
Yes,
officers.
that is there in
And
the
the
section.
fourth is the executive magistrates.
No, I just want to avoid first appeal going to the High Court.
The appeal will go to the High Court.
Appeal will
No, first appeal. Anything less than 7 years, the appeal must go to the session judge, no?
Yes.
So even
Yes,
now
even
the
now it
appeal
will
will go
happen.
to the session.
Well, there's a lot
Appeal
of
will
grey
now
area.
still go to the session.
I accept what you say, but criminal lawyers in Chennai have told me that the appeal will go to the High
All
Court.
right, let me raise another, let me raise another issue. Now, under the old law, if the sentence was 10 years and you've served 5 years, you'll automatically be released, right? The new law says you won't be released if you are also charged with another offense,
Yeah.
Yes.
right? Which means that if you have some charged with some other petty offense, they don't say which category of offense. Any petty offense, for example, you will not be released.
No, even in the same crime, there can be 2 sections, both will be counted as 2 offences.
Yeah, but I don't think that provision will apply to one transaction. This is with respect to a
No,
second.
No, why
it
not?
always uses the word multiple
I
crimes.
doubt it. It is with reference to another offense altogether, not part of the same transaction. This is what I think.
It is a different offense,
Yes.
not offences in the part
Part
of the same transaction.
Therefore, if you-
Otherwise, a person will never be released for instance, in one
Yes.
transaction, there can be multiple
Correct.
offences.
so that will not apply.
Does the police agree with you? They have their own interpretation.
Yes.
But it also uses the expression multiple crimes. No?
Multiple cases.
So what is the multiple cases?
Multiple
What is
cases.
the difference between two or more offences and multiple
Different.
cases?
There is a difference. Multiple cases, there is a separate offense that you have committed. It's a separate case altogether.
But that will come under multiple crimes.
No, it won't. That's one case with multiple offences in one case, because you can be charged under the Organized Crime Act, you can be charged under the regular provision. Even today, you can be charged for several offences.
Why use language which creates this ambiguity?
That's another.
This should have been clear.
That's another matter. But as I said, I mean, this is done in a hurry. It is done to show to the world, see, this government has brought about enormous changes. We have modernized our criminal justice system, though this is nothing to do with justice. This is something to do with enhancing fear in the minds of people.
And punishment.
Now there is another addition which they have done is, if a complaint is filed before the magistrate, before directing registration of FIR, a provision akin to section 156(3) CRPC, a police report will be called. But if it is a public officer against whom the complaint is there, then that public officer will be heard and his superior will also be heard to find out if there is any case made out. Secondly, the preliminary investigation permitted contrary to Lalita Kumari's judgment under section 173(4) BNS says that the scope of preliminary inquiry will be whether a prima facie case is made out or not. So even at that stage, police can go into the truth of the allegation, unlike what was said in Lalita Kumari, that all that the police can look in whether the complaint discloses the commission of a cognizable offence. Contrary to that, if a complaint case is filed before the magistrate, he cannot direct registration of FIR unless he cannot summon the accused, but he will have to first issue a notice and ask what he is saying. So the accused will be heard at the pre-cognizance stage, and once it is found out, then cognizance will be taken. So what will you call that first stage? Storage of notice and then summoned as an accused. So there are fetters on the powers of the magistrate, but as far as the police powers are concerned, or registration of FIR, going ahead with the arrest, the law has been simplified.
There is another issue here. Under the law now, under Lalita Kumari, if you have committed a cognizable offence, the FIR has to be registered.
Has to be registered.
That's done away with now, under this law, right? The police officer has the discretion not to register. So this is where politics will come in, right? If you are a member of a particular party or known to you, then that police officer will not register the FIR. He will start doing a preliminary inquiry, and there is no time limit for that. And if the person is inimical to you politically or otherwise, he'll immediately register the FIR.
There is a time limit given of 2 weeks, but the fact is, he will find out prima facie case made out or not.
Yeah, but he will not.
He will say that no case
at
is
the
made
moment,
out.
no case is made
Cases
out.
made out.
So what do you do?
And that's the end.
There is no protest provision there.
There is no
It
protest petition at that stage.
This is the problem.
Under the new law, you can't file a protest petition.
No, not in a case where he says.
Where the police says no prima
no
facie
prima
case was
facie.
made out,
Where the
they
protest-
close it. So then
So
you...
that's the end of
That's
the
the end
matter.
of the
Yes, and then when you go to the magistrate to get the FIR registered, they will first call the police report.
That's right.
Report from the police. The police will say no prima facie case is made out.
This is
Now,
the problem.
if the magistrate takes the route of treating it as a complaint case and summoning, then he will first call the accused, hear him whether any case is there, then take cognizance against the accused.
But how will the accused defend himself, because he won't have any documents?
He won't
with
have
him.
any documents.
So he can't defend
No,
himself.
no. This is not an accused defending himself.
No, I'm
This
just
is
saying.
an
Even
accused,
cognizance.
And-
resisting a case.
And
Correct, but
imagine
how will
a
he
case-
resist it?
Imagine a case of a complainant where the accused is unknown.
Yeah.
If the accused is unknown, which is there in many cases.
Yeah, theft, burglary,
Yes, yes,
etc. You don't know
So
that.
this
You
is
don't know
obviously,
that-
therefore, these particular laws are a lawyer's paradise.
It's a
No, it's actually carte blanche to the police.
Of course, that it is. That's why it's a lawyer's paradise. Because the more the police does whatever it normally does, the more opportunity for the lawyer to say, look, what is happening in my country.
And meanwhile,
terrible, it's
justice will suffer, people will suffer
course.
because of the police excesses.
Yeah.
See, as it is, the complaint is police have too many powers,
Yeah.
too little restraint, too few restrictions. This is giving a
Wide
wide,
powers.
But this is the modernization.
And no accountability.
And no accountability. This is the modernization of the law, is what they've done. That they say they do, they've done. And in fact, it is going back to the, Middle Ages. I mean, this is what Rajas used to do. Put somebody in prison, no accountability. Well,
the only hope is that quickly the courts, or certainly the Supreme Court, must list a dozen provisions which are seriously affecting liberty and are prima facie unconstitutional and decide that.
problem,
You can't have case by case coming from one provision challenged here, one provision challenged there.
the
That
problem,
will
the
take.
problem is that if somebody says, how does 32 lie?
No, you can file it under 226 and then, no,
Yeah,
fundamental
226 means the High Court, there's several
Fundamental,
parti-
fundamental right 32, Article 21, it will lie in the Supreme Court. But we'll have to, the lawyers' body has to get together and list, say, 10, 15 provisions which are serious invasion of liberty and bring it to the Supreme Court.
That I understand, but if it goes to a particular, benches, it all depends on how the bench is going to see these things.
Yeah.
Saying, you let the High Courts decide first, then we'll deal with it. So, it's very problematic. This whole situation is very problematic.
Yeah, but the Salem Advocates Association case with regard to the CPC, amendments in the CPC, I mean, it was a composite petition saying that these are the 7 or 8 or 9 problem areas. I think a similar kind of a petition should be entertained by the
I
Supreme.
think that this jeopardizes freedoms in our country.
Oh yes.
And we can't be at the mercy of a state which uses the police to destroy what little is left of our freedoms. But thank you very much for being here for
Thank
this
you.
wonderful
Thank you.
discussion.
Thank you very much.
Thanks.